like Dave said, we're going to be covering the draft rules, starting with products. The rules subcommittee of the Psilocybin Advisory Board is following this schedule. So we still have another. We had one rules advisory committee, but coming up quickly on. There's been final OHA review in coming weeks of the draft rules, and they'll be published in the Oregon Bulletin. The links there to see the rules themselves. One of the key things is that we now know the categories of psilocybin products, that there are going to be 4 product types that have been identified. Psilocybin producing fungi, mixtures of substances containing detectable psilocybin. So that's going to include 1 whole fungi, dried fruiting bodies and sclerotia of our 1 species that's allowed, Psilocybin cubensis, that have not been homogenized. So the whole fungi would be obviously the whole mushroom. So these would be whole mushroom products that haven't been chopped up or altered from their whole state. They did include the word sclerotia there. My understanding is that Psilocybin cubensis actually don't have sclerotia, but of course these are draft rules, so subject to the comment. So perhaps that'll be removed from the final version of the rules. Second product type would be homogenized fungi. So as described, would be making a type of powder or other way of chopping up or uniformly distributing the psilocybin throughout the product. These products may contain inactive ingredients, which is something that's mentioned throughout the other psilocybin products, is that they're kind of emphasizing inactive ingredients. This definition actually doesn't include the species limitation. Note that the whole fungi does, and some of the other definitions do. But it's just sort of perhaps a drafting note. The other third psilocybin product that we've identified as extracts, psilocybin extracts, solid or liquid psilocybin, which has been extracted from the fruiting bodies or mycelium of our species, Psilocybin cubensis. And again, rules aiming to limit the extracts to inactive ingredients here. So that's also a part of how they're classifying this type of psilocybin product. And then finally, they also include edible psilocybin products, which would be psilocybin extract or homogenized fungi that have been incorporated into a food item or a potable beverage. There's also a definition tincture, which is not actually mentioned anywhere else in the rules, aside from being defined. Under OLCC rules governing cannabis, tinctures are treated pretty much the same or similar as cannabis edibles. So I suspect that's what they would be intending to do here. Just allowing perhaps a higher concentration or a higher potency, depending on how those shake out. There have been some heated, exciting exchanges on the board about units and dosing and what kind of uniformity might be possible within the rules, given the kind of variability that actually exists amongst mushrooms. So we also have the definition of tincture, which I would consider probably be an edible product, but that could be clarified, I think. In the rules, we also have some requirements for what the manufacturer license must do. So of course, the manufacturer license being necessary for manufacturing any of those product types. The manufacturer has to follow typical Oregon Department of Agriculture, ODA, food safety requirements. The psilocybin products will need to be stored in a locked area when not in use. These are controlled substances, so there's concern about diversion. And so they're adding the requirement that they be locked away when they're not being used. And then of course, tracking, there needs to be a unique ID number for each process lot, which will be how they're sort of divided. Each lot of, similar to cannabis, of psilocybin products will be given a unique ID number to be inputted into the tracking system. And none of the products can appeal to minors, again, similar to OLCC cannabis and alcohol. And so as the manufacturer license is the type of license that's required to manufacture, there are these different endorsements for each different product type. So we've got fungi cultivation for the presumably homogenized fungi, and then also the whole fungi. And we have a psilocybin extraction and edible psilocybin production licenses. Any manufacturer can hold multiple licenses and multiple endorsements. So one could cultivate and extract and create edibles at the same location. Dung is prohibited, and wood chips are also prohibited as growing medium. Genetically modified organisms are prohibited, and synthesized, no chemical synthesis is allowed, sort of unlike the most of the controlled studies to date have all used synthesized psilocybin, so or mostly. There's a large section about adulterants, which is a bit, there's a understandably the advisory committee and the rules want to prevent harmful substances from being introduced to these products. So they've got a rather broad definition of what might be considered an adulterant. I've italicized some of the language that could be interpreted rather broadly. This is any chemical, drug, plant, or substance that has the effect of altering potency, intoxicating effect, duration of effect. Of course, introducing food, I mean, commonsensically, they've got a category for edible psilocybin products. So presumably adding chocolate, for example, that would reduce the potency by volume. But I think they're aiming at trying to be protective here. I think that it's a little somewhat of a concern as somebody who'd be interpreting these rules if you have a creative business who's wanting to introduce additional, potentially not harmful additives to a psilocybin product, whether or not it's an adulterant or not. I think that's an issue that I would potentially anticipate. So I expect the OHA might get a lot of questions about whether or not they can add this or that substance to the psilocybin products. Again, another sort of broad provision that creates this, again, a prohibition on any substance that's added to make it appear of better or greater value than it otherwise is. So, I mean, that's open to interpretation what that might be to add as an adulterant, which would not be allowed. I think another important part of these rules that has been adopted following the recommendation of the Products Subcommittee, and I think going back to the issue of trying to, as much as possible, aim at some predictability, perhaps, and to reduce the variability, is the intent is to limit the manufacturers to only one species of fungi, Psilocybin cubensis. This prohibition is written rather broadly and stringently, in my opinion. It says a manufacturer may only cultivate or possess the fungi species Psilocybin cubensis on the licensed premises. To me, and then it goes on to say incidental possession of other species is allowed within employee meals, but this would sort of suggest that basically once you've declared your premises, no other type of fungi is allowed there, which that will create challenges, I think. There's talk, and I think the intention of discussions on the advisory board and the products committee in reaching this kind of single species limitation. They were talk about, well, we can add species later, which they could, but it would require a rule change. And the whole process of all that and the political will and initiative to do that. There was talk of a mechanism in the rules to do that, to sort of revisit it on a periodic basis, but there's nothing in the current rules about that kind of review being required or implemented. So at this point, there's still only one species, and it would require a rule change to add. I think it also really will come down to the limitation, because it's how is the premises defined, and then how might someone how might someone divide a premises or segregate it? And so looking at the definition from the Act will be determinative to say, okay, can we start doing some other activity, growing some other type of fungi, you know, chanterelles or leather mushrooms or button mushrooms or whatever, in a different part of the area. So that delineating the premises will become essential. This is something that also happens on cannabis, where there will be a tax lot with multiple premises on it. So there are ways to do that, to have doors and walls to separate things, but that will be kind of part of it. And I think a big business consideration, because you know, whether or not it will be viable to be growing this single species of mushroom, if that's the only activity there, I think that would pose a business challenge to anyone. Like I mentioned, the adulterants, we can also see that being a potential issue. I think perhaps it'll shake out, you know, in a lot of more developed industries, they get very granular in terms of what can and can't be added to the ingredient level. Maybe we'll eventually reach some point like that. I kind of hope it doesn't have to get that intense, but I could see that potentially happening, getting more specific, because there are certain things that are added and people want to add and are allowed or not allowed. Yeah, I think because mushrooms are relatively easy to propagate, I think there'll be a lot of competition potentially amongst different manufacturers. So again, that species limitation for a single premises might create challenges for a business if that's the only activity they're doing there. And being prevented from other activities at the premises can also kind of hinders the businesses in developing in other ways. So for example, federal trademarks are only allowed for federally lawful activities. If a business is operating on a premises and they're not allowed to do federally lawful things, they're only allowed to grow Psilocybin cubensis at that premises, you know, that restricts them from doing other things and might limit their ability to protect their brand name. There are also issues that are similar in cannabis, where people attempt to segregate their non-trafficking activities from their trafficking activities, trafficking being touching the controlled substances and non-trafficking being other things. And so again, this species limitation on the premises could have tax consequences for however the business is structured, if they decide, you know, which sections of their property might be allowed for cultivating, really, which is trafficking, and limits the business deductions as a result of that under the Internal Revenue Code. So consequences of this single species requirement for the premises. And that's all I have to say for now for products. I think we'll have a further discussion later, but wanted to give that overview so people have kind of oriented to the highlights, and I'll kick it over to Alex to talk about testing.
Thanks, John. So now, for the moment that everybody's been waiting for, we're going to talk about the most exciting subject, which is the draft testing rules. So the link to the draft testing rules is right there at the top. And then in terms of timelines, there was a Rules Advisory Committee meeting earlier today. Then based on the Rules Advisory Committee's comments, that there's going to be some revisions in the upcoming weeks. And then on April 1st, the OHA will be publishing the second draft of the rules in the Oregon Bulletin and submitting them to the Secretary of State, which triggers a public comment period, which ends with public hearings where folks can provide testimony and their opinions about the testing rules. And then it's estimated that the rules will become effective May 13th. Next slide. So in the draft rules, there are 6 types of tests. The first is speciation, which is a required test for whole fungi prior to any transfer or processing by manufacturers. And that test is required to verify that manufacturers are only manufacturing psilocybin cubensis. The second test, which is also a required test, is for potency, and that applies to all finished products from whole fungi, the dried fungi, to extracts to edibles. And that is simply to verify that the amount of psilocybin or psilocin between samples of each test does not exceed 20% relative standard deviation. So to make sure that the amount of psilocybin is consistent between samples. We expect that with further rules coming down the line, it's likely that there will be maximum potency amounts and dosages. And so those will probably apply to potency testing down the line. The third type is solvent testing, which is required only if the processing method you're using includes the solvent methanol. And then in that case, remediation may be permitted. So if you fail a test, you may be able to remediate that level of methanol down to an acceptable level. And I should also mention, for potency testing, remixing will be permitted of the product to make that deviation in psilocybin more consistent. Next slide. Pesticide testing will only be required upon OHA request and could apply to both unfinished and finished products. And that test is to verify that pesticides are not above action levels as set by the Oregon Department of Agriculture. And in that case, if your test fails, remediation is not permitted and the testing batch must be destroyed. The next type of testing is microbiological contaminant, which again is also only required upon request by the OHA, could be applied to unfinished or finished products. And the point of that testing is to verify that there is not the presence of E. coli over a certain amount. Again, their remediation is not permitted. So if you fail a test, you'll have to destroy that test batch. The next type of test is heavy metal testing, which again is only required upon OHA request, could apply to both unfinished and finished products. And the point of that test is to verify that certain metals, namely lead, cadmium, arsenic, and mercury, do not exceed certain amounts. And again, remediation would not be permitted in the event of a failed test. Some other notable rules for failed tests: reanalysis is allowed within 30 days. And that reanalysis would have to be conducted by the same testing lab. And then if you pass the reanalysis, a follow-up passing test would be required from a different lab. And those rules are pretty much taken directly from cannabis testing rules. In terms of testing batch sizes for whole fungi, it would be 5 pounds maximum per batch. And then for other processed products, it would be the entire processed lot of those products. So, you know, the entire lot of an edible that's made at the same time under the same SOPs, using the same methods, etc. Interestingly, and unlike the cannabis testing rules, manufacturers may choose to transport their own test batches to labs for sampling rather than requiring lab personnel to conduct the sampling at the licensed premises. Also, just like cannabis, research and development tests would be allowed, in which case you would not have to destroy your product in the event of a negative test. But that applies to all testing except for pesticides, because under Oregon law and Oregon Department of Agriculture regulations, you must destroy a crop that tests positive for pesticides. Next slide. So some interesting issues that that cropped up, in my opinion. One is the rules do not define what the penalty is, or if there is a penalty, or what the result of a failed speciation test is. So if a whole fungi testing batch tests as some species other than Psilocybin cubensis, what is the outcome there? Although Measure 110 has decriminalized other types of psychedelic mushrooms, that doesn't mean that they are lawful. So will OHA require the labs to refer those negative tests to law enforcement? Will a lab technically even be allowed to possess non-Psilocybin cubensis? That has to be worked out. And then in terms of potency tests, there's that 20% standard deviation threshold. And the question there is, you know, how much difference is there between individual Psilocybin cubensis fungus? I mean, if naturally there's more of a 20% differential from one whole fungi to another, it's going to be hard to pass those potency tests. And then this was something that was brought up at the Products Rules Advisory Committee last week, but there was the suggestion that pesticides should be banned outright rather than being able to test at a certain action level, because the fungi itself is very sponge-like and is likely to absorb any pesticides that are used. Also, 3 of the tests are at OHA discretion. So OHA requests pesticide testing, heavy metal testing, or microbiologicals. And so it's going to be interesting to figure out how the OHA is going to determine who needs to test, when they need to test. It's likely that all of the testing is going to be paid for by the licensees. So if one licensee ends up having to test their products over and over again, it would be unfair and unequitable. And then also, is discretionary testing safe? If you're only testing occasionally for pesticides, microbiological contaminants, and heavy metals, does that guarantee a high enough level of public safety? And then perhaps most importantly and most significantly, are laboratory businesses attractive? There are going to be heavy upfront equipment costs. There's a much smaller customer base than cannabis. I mean, there was already a robust medical system when adult use cannabis came online. So, you know, folks were rushing to start licensed labs. But, you know, we anticipate that there are going to be far fewer psilocybin manufacturers. Much smaller amounts of psilocybin ultimately are going to be sold and consumed than in the adult cannabis space. So whether it's going to be economically viable to start a lab is a big question. And we're going to need at least 2 licensed labs for folks to be able to request reanalysis of mushrooms that fail the initial test. And so obviously, if there are lack of labs, that would affect supply chains for products and pose potential bottlenecks. And it was interesting that in the Testing Rules Advisory Committee meeting that was just this morning, this was not mentioned, but it seems to make the most sense to possibly license OLCC labs that are already licensed by ORLAP and the OLCC to test cannabis products, because presumably they're would be some overlap in terms of equipment, infrastructure, et cetera, that OLCC approved cannabis labs would be in a better position to serve the psilocybin industry. But it's likely that OLCC will have to change some of its rules in order to make that possible. Next slide. So hot off the presses, there was a testing rule advisory committee this morning where various experts on the committee made comments on the draft rules. And some of those comments included, in terms of speciation, it was suggested that testing should be required at earlier stages in the life cycle of the fungi rather than the fully grown stage, because if you fail at the fully grown stage, you know, it's questionable as to whether you'll be able to use any of the mushrooms in that harvest lot. And if you test earlier, you will. I'm not a microbiologist, but my understanding is if you test in earlier stages, then it's likely that the adult, for lack of a better word, mushrooms will all be the Psilocybis cubensis. In terms of potency, there was some discussion about how the shelf life of the mushroom in terms of potency does degrade over time, and so there may have to be an expiration date on the potency testing and the potency numbers. In terms of pesticide testing, again, there was discussion that it's unnecessary to use pesticides in the cultivation of the fungi because they're largely grown indoors, and it's actually more likely that bacteria will form on the fungi, and therefore antibiotics can be used to combat bacteria, and therefore antibiotic testing may be more appropriate than pesticide testing. There was some talk that there should be an increase in the number of solvents allowed, and therefore there would presumably have to be additional testing for additional solvents, and some microbiological contaminants in addition to E. coli, it turns out, may appear on the fungi, and so there was suggestion that there would be additional testing for Aspergillus as well as fecal coliform, because although dung cannot be used as a fertilizer, it turns out that pasteurized dung may be used as a fertilizer. I was unaware that you could pasteurize dung, but it turns out that you can. And so in that case, fecal coliform testing may be appropriate. It was also suggested that 5-pound batches for whole dried fungi is extremely large in terms of a batch size. And that it would be the equivalent to something of on the order of 750 doses theoretically. So there was some talk about maybe cutting that batch size in half. And then there was also talk of remediation, and that there isn't a lot of data on whether products could be remediated that contained heavy metals at certain levels during the processing process, and that with further processing and extraction, it's possible that the heavy metals could be eliminated. The same goes for molds and microbiological contaminants. So OHA may be looking into allowing remediation for further products, so long as they ultimately test below those action levels. So that is all I have for testing. Dave?
Oh, thanks, Alex. Okay, training rules. I am really interested in these because they a little bit forecast the issues that will come up later in the year when the OHA promulgates the rules around the preparation session and the administration session. And I'm really interested in how those go, because I think from a market perspective, a business perspective, a client perspective, how that gets laid out will really perhaps determine or certainly influence how many people will participate in this market. Nobody knows right now how many licensees we're going to have. Nobody knows what the price points are going to be. Nobody knows whether there will be a big client base for this based on the price points, especially when there's a competing underground market and things may get expensive. There's been a lot of focus on equity and accessibility and affordability, super important stuff. But I think a lot of it might come down to the kind of hard-boiled, business aspects of this thing when you end up figuring out how much it's going to cost, because there's no Medicaid or insurance or anything like that to help people get along. Clients are going to have to come out of this with their own pocket unless there's some sort of charity, and businesses will have to make a profit. This is a competitive system, and so everybody can get along for sure, but at the end of the day, to keep your doors open, you're going to have to make money or at least break even. So I'm really interested in this stuff. So go ahead, Sean. Let's go to the first slide here. I'll try to whiz through the rules themselves. They're a little straightforward. There's a training program approval. So this is the program. The OHA has made it clear that they are not licensing the entities that offer the program, that they are basically approving the program itself. And there will be something called a training program applicant. The rules which I'll get to in a second, will cover the curriculum, pretty affordable evaluation fee, 5-year term, which is quite long. I think some folks thought it might be a little shorter than that, and we'll see if the rules get changed on that. The requirements. Oh, by the way, these numbers in parentheses are the sections of the rule numbers. So that's why those strange numbers are there. The application requirements are logical and straightforward. There'll be 2 lead educators. They will be responsible for tracking the student's progress. The application will list the instructor's qualifications. That makes sense. There'll be a program director. And so that'll kind of be, from a training program perspective, part of the application. Go ahead, Sean. Thank you. Qualifications and performance. This is also, I think, pretty straightforward. Trainers must know what they're doing, have some experience, knowledge, skills, how you sort of, on the front end, display or convince the OHA that you have the knowledge and skills is kind of an interesting question, but there you go. You've got experience, knowledge, and skills, and there's a notification process. I don't know how material changes in the curriculum. So material changes. Material is a very favorite word of lawyers and rule makers, and so where you exactly draw the line, who knows? But presumably you'll have to sort of submit that from time to time if you change up your curriculum. There's a reapproval process. This is presumably after 5 years. There's a denial section. This would be both on the front end and reapproval, I suppose, if you make false or misleading statements, or you're not complying with the rules. The OHA noted that they're going to go ahead and add a cancellation rule, which will basically mirror how a training program would be, I suppose, de-approved if the training program wasn't complying with the rules. Okay. Training requirements. I don't know what everybody thinks about this. I think there's some folks who think this is too short. Some folks think this is too much, but we've got 120 hours of instruction, 25% in person, 50% of training. So that's, let's say 30 hours. I suppose the instruction could be as long as you want, but it's 120 minimum hours, 25% in person. That would be at least 30 hours of in-person teaching. At least 50% of the training that's not in person would have to be through online synchronous learning. there's 9 curriculum modules spelled out in the rules. The training requirements list a minimum number of hours that must be spent on each curriculum module, which we'll get to in a second. And there's an additional 40 hours of practicum training requirements. So this is observing and facilitating actual psilocybin services at a practicum site. In the beginning, I think you've got a little issue here because there's not going to be any psilocybin for the class of 2022, right? The first class of facilitators that goes through, they're going to not be able to sit and actually observe facilitators in action with real psilocybin, but they'll do so through an alternative means, which I think makes sense. So, and 40 hours of training, 30 direct practice, 10 consultation. Okay. Thank you, Sean. Here's the curriculum modules. There's 9. It's really interesting. I didn't spell all this out here, but in the rules, the rules really break down like what each module is. So historical, traditional, contemporary practices and applications, there's a whole laundry list of subsections that kind of spell that out. And so I didn't list all the subsections, but that's really interesting reading. I did put a parenthetical around preparation and orientation, so I want to talk about that in a second. But they mention a client information form. They mention referrals to specialized treatment centers, screening for risk factors, clients' suitability, safety planning. This, to me, we're going to get into in a second, but is telegraphing perhaps a direction that the board and the OHA is going, although that remains to be seen. I think in the first draft of the rules here, I assume the OHA left open the possibility for this stuff, but the preparation and orientation, what that's comprised of is a number of important things where the rules are not really set out yet. So it's a little bit of a chicken and egg thing there, but we'll talk about that in a second. Administration and integration, group facilitation is just there. So when I first saw that, I was like, yay, we're going to have group facilitations. I always thought we would, but they weren't basically required to be allowed by the act. The OHA could have said we're not going to have group facilitation, but it seems like they're on board with that, which is good. Okay, class of 2022 challenges. What I see, and this is not my area of expertise, but I'm just observing here. How do you train someone for preparation sessions and administration sessions and integration sessions and all of the things that are set forth, especially in the orientation, the preparation orientation section module, when those other rules haven't been written yet? The administration rules haven't been written yet. The client information form has not been finalized yet. What facilitators will do with the client information form has not been finalized yet. So it's interesting that a module has to contain that, but it may very well be that those rules aren't written till that these courses are already underway. People have signed up for these courses. The training programs have been approved, but the rules for these sessions have not yet been finalized. And I'm just observing that there's kind of a what comes first issue there. And then I talked about practicum training. You can't have training involving actual psilocybin sessions, at least not in the United States, until I guess the class of 2023, and the program gets up and running. Okay, so I'm deviating or going a little bit beyond the rules here, but it does relate to that section of the rules that talks about the client information form and the suitability factors and the risk factors and all that. There was a training subcommittee meeting, I think 2 weeks ago, which adopted a client information form. The subcommittee adopted it. And I think the procedure here is a subcommittee adopts something, brings it to the Psilocybin Advisory Board. It'll be debated there. And then at some point, the board will make a recommendation to the OHA. Now, I think this is perhaps the most important issue I've seen so far as exactly how this is going to shake out. And bring it up now because again, we're going to be training for this stuff before the rules are finalized. But, and we're only at the very early stage of this, but the subcommittee listed a client information form. And by the way, Measure 109 says that there will be a client information form, but it basically defers to the OHA as to what the contents of that form will be and what will be done with the contents of that form. But I was a little concerned that the form adopted by the training subcommittee went really, really deep into what one could say was many medical issues. There were a lot of questions, and I think during the subcommittee meeting, other people started just throwing on other things to ask about. But a client's, now again, this is going to take place at a preparation session or perhaps in advance of a preparation session. But please, list your medical and mental health history, your history of mental health issues, your trauma history, including childhood trauma. I mean, just look at those three. Very open-ended. These are not yes or no questions. These are open-ended questions that I think dig kind of deep or could dig deep. Suicidal intent and attempts, psychological disability, substance use history, prior use psychedelics, support network, your current living situation, your list of medications. This is just an example. This list went on and on. Now, I might say that is very medicalized, that you are really digging in there. And certainly some folks believe that it's really useful to know all this stuff. Like in a perfect world, a facilitator would learn as much as possible on the front end about a client and everything that could possibly come up. So that's what the form says. Now, of course, the question is the next question is, what are you going to do with that information? Sean, why don't you go ahead and flip to the next slide? Thank you. Remember that facilitators do not have to have any kind of license, any other degree, right? They will have a facilitator certificate. They will be this is a new class of a professional, but they don't have to be physicians. They don't have to be psychologists. They don't have to be anything else. They can be nothing but a high school graduate who took the training course, passed it, and I'm a facilitator. So what is a facilitator going to do? At the training subcommittee meeting 2 weeks ago, that was the second question. I also found it a little interesting that the subcommittee approved the client information form before they discussed what they were going to do with it, what they're going to do with the information. So then, okay, then they get to what are we going to do with the information? And the idea was that the facilitator, it'd basically be an eligibility test. So the facilitator would throw the client or make a determination that the client was, here were the categories set forth. There was a no safety concerns and a minimal level of risk. Green light, client's ready to go. No safety concerns and a moderate level of risk. What does that mean? Well, who knows? Minimal, moderate, those are more sort of line drawing words without a clear line, just like material, just like reasonable, just like a whole bunch of other legal terms that are used. Client is eligible after informed consent, that's fine, and an additional safety planning process, which could include consultation with one or more other licensed professionals. Okay. And then that's a yellow, let's call that a yellow light. Then you have the next thing, immediate safety concern, high level of risk, client's ineligible, red light, you can't go any further. So next slide, please, Sean. What pops into my head, I'm always trying to envision how a business will run. how will businesses deal with this? What will the client experience be? And I'm not saying this in a derogatory way, but I'll refer to them as lowest common denominator facilitators. These are people, these are folks without any other degrees. This is a question I'm posing. I'm really interested to hear this discussion. Are these folks qualified to categorize clients based on 101 questions that you're giving them that are very open-ended, involving many personal client information, health history issues? What would be the tendency of a facilitator with that information? And then if you decided to, I mean, if somebody checks no, I guess you're okay. But somebody starts opening up about one thing or another and develop tailored self. Now I, as a facilitator, have to develop a safety plan, or if I'm going to lump somebody into a moderate risk, what am I going to do there? Am I going to come up with a safety plan myself? Am I going to just refer that over to another professional, which would be another gatekeeping way before? I mean, what you're telling the client there is you have to do something else before you can participate. And that's going to have monetary consequences. And maybe the person drops out. But that is the way they're going. Now, on that meeting 2 weeks ago, I think they got a little stuck on this last issue, and their time was running out, and they had a vote on it. And it was really interesting. It was three votes to approve this structure. 3 folks voted no, and 2 folks abstained. These are people on the training subcommittee. So it didn't pass because it was 3 to 2. So they're going to revisit it at their next meeting. But that's where they're headed. And I'm thinking, how does this affect the training program where rules are being adopted right now? Another issue that came to mind was, and again, this was drafted as a non-medical measure. Clearly, clients don't have to have any medical preconditions, and facilitators don't have to have medical degrees. So the theme from day one was it can become something more in the hands of a particular facilitator and a particular client's needs, but at its bare bones, it is not a medical measure. And I think if the OHA eventually goes this way and adopts all of these client information form and has this entire procedure as envisioned by the training subcommittee, I'm wondering whether a facilitator is practicing medicine by, and here's the definitions in the statute, and not to mention psychology. Every profession has its own statute in Oregon. Lawyers have their own. What constitutes the practice of law? It's defined. What constitutes the practice of medicine? What constitutes the practice of psychology? And it's occurring to me that the rules, depending on how far you go or what you do, it would be a horrible situation, I think, if you had required rules that, in order for a facilitator to follow them, they by definition are practicing medicine or doing something else. I mean, could the Oregon Medical Board come along and say, hey, just so you guys know, every facilitator is practicing medicine. So there goes you can't do that. I don't know if they would. I don't know how this would play out, but it's an issue to be raised from that legal perspective, but also from kind of a business and perspective, and maybe a spirit of the act perspective. Sean, could you go to the next one, please? So I'm also thinking from a facilitator standpoint about their own liability. There's a provision in the Measure 109 that says that the facilitator can rely on the information provided in the client information form. If I go to see my physician or dentist or whoever, and I fill out a little form in the lobby area, and I check boxes or don't check boxes, the doctor or dentist or whoever can rely on the information I provided. That's what we said here. So I'm wondering, well, first I'm wondering about HIPAA. The doctors in the room and some of the licensed folks will understand that HIPAA has really serious privacy and security rules. And as far as I can tell, based on the client information form that was adopted by the training subcommittee, that's totally, covered information. I mean, you're getting into personal health information for sure. And you'd have to build those security systems in place as if you were a hospital. And negligence. This is, what is a facilitator doing? When can a client turn around and make a claim against a facilitator? Professional negligence is kind of interesting. Personal negligence, if I'm driving my car down the road or doing something, it's based on a reasonable person standard. In the professional world, like lawyers or doctors, your negligence is based on your industry standard of care. Now, this is a new industry. We don't have a standard of care yet, unless it's promulgated by the OHA. But it's interesting to me that, again, going with the way the training subcommittee goes, you have all these questions, all this information, you're creating safety plans. How would an industry standard of care go? Would people faced with this kind of process, would facilitators kind of in a knee-jerk way say, well, geez, the safest thing to do is to lump if anybody answers anything, I'm just going to throw them into the moderate level of risk and maybe refer them somewhere else and let somebody else take the heat for giving them the green light to go forward. Now, is that what I could see that from a hyper, I want to protect my own butt perspective liability, but what is that going to do to the entire system? If too many people get thrown into the moderate risk system, you are completely, at some point, medicalizing this system, and you've got a gateway that's going to make people jump through medical hoops in order to get the okay. Not to mention the safety plan. Is the safety plan, if a safety plan involves requiring a client to consult with one or more other licensed professionals, do those professionals know anything about psilocybin? And are those professionals going to ever say yes? Because what's their liability for giving somebody the green light? So I think there's a can of worms here that if you dig too deep, you're setting up some legal issues. And there is a theory, a school of thought that says, and this is not to avoid responsibility or to pass the buck or to make things dangerous, but there is a school of thought that says, maybe the less information I get, the better. Maybe not force people to answer long questionnaires. If somebody wants to talk about something, they can do so. But is there a way where we could make this process more objective so that a lowest common denominator facilitator is not required to do all of these things? If somebody is a physician and a facilitator and they want to do all the stuff, they can certainly do that. Same with a psychologist, same with anybody else. But are we going to make everybody do this? And how will that work? Sean, next one, please. What if a client doesn't want to answer questions? What if I get referred to somebody and I don't want to go see a doctor? I don't want to go see somebody else. Am I ineligible, or can I just do it anyway? And if I can just do it anyway, what's the point of the whole thing? Why not just rely on informed consent? Hey, if you had trauma in your life, this stuff could happen here during this session. If you want to talk more about that, we could do that. But just FYI, here's some information. Here's a paragraph or two written by the OHA that you should understand this could happen. And it's a way to inform people with informed consent, have clients assume the risk, have the OHA do the work of telling people what the risks are, removing some of the professional subjectivity from the facilitator standpoint, and I think some of the liability from the facilitator standpoint, in creating a standard of care that is more objective and makes the entire thing, I don't want to say non-medical, I'll say voluntarily medical, right? If a client wants to talk about it. But if, let's say, I mean, when I first saw that, and I'm thinking of myself, I don't want to answer any of those questions. I'm not, that's why I'm not there for that. Other people might be, but I'm not. And I would not be rude and say none of your dang business, but I would say, well, you really need to know all this stuff? Like, and if they said yes, I'd probably just say no, whether it was absolutely true or not. So are you also creating a system where clients are just going to, oh my God, do I have to fill out this whole thing? I think I'll just say no. And word will get around. Once the system's up and running, everybody will know who wants to participate. Like, oh, if you check these boxes, they're going to make you do this. So you have to take into account human nature, I think, a little bit, and what clients might do. Or, they just stay in the underground because they don't. Now you're adding expenses, you're adding time, and you're adding things that might not happen. Insurance is going to be a super important issue for this, for facilitators who do not have a license and who do have a license. If you are one of those folks who have a license, which seem to be a lot of the folks who are driving the rules on a training subcommittee, if you're one of those folks and you're practicing, I'm just flagging an issue here. If you're practicing, if you're holding yourself out as something more than just a bare bones facilitator, hey, I've got a medical degree too, and our service center, caters to folks with PTSD and serious mental health conditions. I would probably say, well, it depends on what professional you are, but you could be doing two professions at once, right? You could combine your medical skills while you're facilitating. Okay, that's fine. That's not prohibited. But from an insurance standpoint, is your medical insurance going to cover psilocybin at all? I'll bet you that there's going to be an exclusion written into the medical policies for people who do this. And if you're not if you're not a medical person, if you're a facilitator, are you going to are the facilitator policies, the bare bones facilitator policies, going to cover the practice of medicine? So that there could be this squeeze that goes on where I think the facilitator might have to stay in their lane, or the folks with degrees are going to have to really think about how they're who's covering them. Reading insurance policies is probably the last thing any normal person wants to do, but it might be kind of interesting here. And in all that, again, it affects I mentioned equity and affordability in the underground market. So clients will sort of respond to this one way or another. And I just think that I've seen how the cannabis industry has gone. It's very competitive. It gets competitive. Opening up a service center is not going to be the cheapest proposition in the world. People will have invested a decent amount of money into this thing, and they need to make money, and clients have to show up at the door. And how expensive is that going to be? So this is all going to be really interesting. And I think it's not too early to sort of focus on this issue, at least the way I see the training subcommittee going. So it is not to call anybody out, but just to sort of flag some of these issues that I think should be discussed in more detail. Sean, that may be it for me. This is just a leftover slide from our last time. Policies of the Act. It always is good to step back once in a while and say, hey, why are we here and what are we doing? So, and if you create a system that nobody comes to, are you doing anything? So I think bring for cannabis, the idea was always like, hey, let's bring people into the system. Like we want people, we want growers to get licenses. We want consumers to leave the illegal market and to get into the regulated market. It's just good for everybody. And I think the cannabis system was set up that way. And I think it, you know, no system's perfect, but it kind of worked to some degree. And here it's a little trickier because there's just, you don't know yet. And so it's going to be really interesting in 2023. And the rules are going to be very important as to how this shakes out and who's going to, how many people, how many clients we're going to have in year one, and how many service centers we're going to have, and how many manufacturers we're going to have. And is anybody making any money at all? Okay. So that's it for our presentation.